Hello and welcome. This is Legal Focus on TVC News. Today on the program, the landmark Atiku versus Buhari judgment is the climax of decisions emanating from the outcome of the 2019 general election, even as the 180-day window within which to handle all such election petitions draws to a close. And we go down memory lane with former Attorney General of Ekiti State, Gboyega Oyewole, a senior advocate of Nigeria. And later, we'll tell you all you need to know about tenancy on You and the Law. Welcome.
On 11 September 2019, the Court of Appeal, serving as the Presidential Elections Petitions Tribunal, dismissed the petition filed by the presidential candidate of the People's Democratic Party, Atiku Abubakar, challenging the victory of the President, Muhammadu Buhari. The five-man panel, in a unanimous decision, dismissed the joint allegations of the petitioner that the President was not eligible for the poll and ought not to have been returned winner of the election. The tribunal chairman held that the provisions of the law was for the president to be educated up to secondary school level or its equivalent, or worked in the public or private service for at least 10 years without blemish. The tribunal held that evidence abound that the West African School Certificate was in existence in 1961 when the president claimed to have sat for the examination. Justice Garba held that from the totality of the statement of the former army spokesman, there were a presumption that the president has certificates because the army itself produced a recommendation of the former principal of the Katsina Provisional Secondary School that the president stood for 6 subjects in WAEC and expressed optimism he will perform well if enlisted into the army in 1962. On the issues of alleged lying and oath, the tribunal disagreed with the petitioners on the grounds that the president did not sow it on affidavits to specifically making claims of depositing his certificates with the Army Board as envisaged by the relevant laws on election. Specifically, the tribunal held that the fact that the president made claims of submitting his credentials to the Army at the point of his enlistment in 1962 cannot by law translate into lying on oath as alleged by the petitioners. The tribunal held that the petitioners ought to have used data from every polling booth to give correct and authentic final election results, adding that it was not enough for the petitioner to have tendered election results from the bar. Justice Garba held that when words of statute are not ambiguous, they must be given their ordinary meaning, which in this was not done. Petitioners did not establish how the use of INEC election manual and guidelines substantially affected the collation of election results. The tribunal held that the evidence stating that the election results was altered, depleted, and manipulated against the PDP's candidate was manifestly unreliable hearsay that could not in any way be classified as expert opinions. The tribunal also held that the petitioners could not adduce with concrete evidence that the results of the election were electronically collated and transmitted as alleged. Rather, the evidence of the petitioner's expert witness contradicted the petition itself because the witness admitted obtaining his information from a whistleblower site whose identity could not be ascertained. On the issue of overvoting, mass rigging, harassment, and intimidation, arbitrary arrest, the tribunal held that the failure to join the security personnel alleged to have committed a crime as respondents to defend themselves was fatal to the petition. In the final analysis, the five-man panel of the justices of the Court of Appeal unanimously held that the petition was without merit, liable for dismissal, and was consequently dismissed in its entirety without court against the petitioners.
Our learned friends, my lord, it's a full court and a long list.
There were mixed reactions in the court on the judgment delivered.
Which directly affects is various or jurisdiction.
Counsel to the People's Democratic Party, Levi Uzoku, says the judgment delivered will be studied and they will come up with their next line of action in due time.
We've done our job. The court has also done its own job. This is the beginning of the journey. Certainly, I don't think that this is the end of the journey.
There's no question about that we are appealing this judgment. A lot of things are wrong with it. Poor evaluation of evidence, non-evaluation of evidence, misplacement of exactly what the case of the petitioners is.
This judgment is an insult and provocation on the Nigerian people. This is turning the law upside down and using the principles of technicalities to rob a man who was freely given a mandate by the Nigerian people.
The All Progressives Congress, for its part, says it is a victory for the rule of law.
Today, the Presidential Election Tribunal have settled the election petition and have found that the mandate given to President Muhammadu Buhari and his Vice President by Nigerians have been upheld by the court.
It's my hope that we allow the matter to rest here so that we can move on with the country. So our president's life experience has taught us one thing, that losing an election in court need not be the end of one's political career. So I think it's for Nigeria that we put this thing about election behind us.
With the judgment, the PDP says it will appeal to the Supreme Court for a review.
You're watching Legal Focus on TVC News, and now it's time for The Advocate. This segment takes us into the world of legal luminaries of our time. And today we have Mr. Gboyega Sanmi Oyewole as the advocate for the week. Let's go to the beginning, childhood days, and the point when you knew you were going to be a lawyer. Or was it always law for you even when you were young?
Well, I was born into the home of very strong educationists. My dad was a school principal while I was a student. But my dad read physics maths in the university, and naturally he wanted me to toe his line by going to the sciences. Well, unfortunately or fortunately, I decided very early in life, when I was even in the primary school, that I always wanted to be a lawyer. And I've made it my focus. It's actually a dream I've had since I was in my early days at the primary school. So I didn't just stumble into it.
Right, but were there influences to feed your young mind then?
Yes, there were the big names that we learned about while we were at school. We have people like Chief Afe Babalola, who is from my state, and it was till tomorrow more of an idol in my state. I grew up hearing his name, and I grew up admiring him. And then much later in life, we started hearing, well, from my own perception, about Chief Rotimi Williams and Chief G.O.K. Ajayi. And these are big names, and those names inspire.
But tell us about your tutelage.
Finishing from Ife in 1989 and then law school 1990. Like you already rightly mentioned, Chief Abala has been a heavy influence on me. So I went to his office for my law office attachment from the law school. And I was also fortunate, after completion of the law school, to be posted to his chambers for national service. So I started my career effectively with him as a law student and as a law graduate and as a lawyer. And then I must tell you, it was really tough. It was a very, very, very tough person. If you did 99.9% of an assignment right and you got 0.1 wrong, you pay for it. Let me tell you something that happened when I was with him after 3 years. We got this case from Oyo State government, and it was a census after the population census exercise of 1993. Oyo State was disputing their figure, and they came to him. And then we had to go and conduct, what's it called again? Conduct another census. And
for Oyo alone?
Yes, Oyo State alone. And he sent us to the field. I was sent to a rural area. We were expecting so much that after this assignment, we were going to get a lot of largesse from Chief. Well, what he did after the assignment, he wrote us all the same letter saying that he thanked us for a job well done. But that while we thought we were working for him, we were indeed working for ourselves. And that has been the story of how he brought a lot of us, his boys up. In
the midst of all these years that you have practiced as a lawyer, let's look at the highs and the lows. Like that big case that everybody seemed to know, or everybody concluded that there is no going back for Gboyega Oyewole.
Well, immediately after I left Chief Ayebola, I had a litmus test of a case. That was Bola Ige murder trial. I was counsel to the first defendant, or accused person. That's what they called them in those days. That was Alani Omishore. That was a case that really tested everything about me, because a lot of senior advocates then rejected the matter. I mean, understandably so. The Attorney General of the Federation had just been murdered, and there was a set mind as to who perpetrated it and the entire story. So when I decided to stand for the first accused person, who then, Alani Omishore, who then was alleged to be the person seen to have gone into the premises, my mother came to Lagos from Ekiti and she was crying. A lot of my friends protested, so many protests. But I believed in what I wanted to do. I believed in the innocence of my client. So I went into the case with everything I got. And then eventually, I was the one that started the cross-examination of the star witness, Andrew Olofu, who said he saw Alani Omishore. And on that cross-examination, he admitted that the weather wasn't good enough for him to see anybody, and that he could not affirm, and that he was told to mention the name of Alani Omishore. And of course, the entire case crumbled at that point. So that was the first major test I had, and I thank God I survived. I survived it because I believed in what I did.
And being a member of the profession yourself, there must also have been a burden on your mind in that trial, even though you were on the other side.
I'm sorry to interrupt you. I felt that the police did a very bad job. You see, we have a problem in this country. Immediately anything happens, they look for scapegoats. No investigation was conducted. A list was just sent to the police as to the possible suspects, and the police followed it. No investigation of any type was conducted.
Do you have any regrets?
No, not at all. Absolutely no. I actually thank God.
Do you feel vindicated?
Highly vindicated. And that's why I still feel that the government should not close the Bola Ige matter. The investigation, fresh investigation should still be conducted, because they had the wrong people then. They could still get the people who perpetrated it. That's why a lot of high-profile murders have gone unsolved in this country. The police will go into their investigation with a set mind, and when it fails, then people will pick on some innocent ones and say, well, they have used their position to get out of the trouble. No. The police should work harder and ensure they are more technical and more focused in investigating murders, be it high profile, be it low profile. It shouldn't be a product of fixed mind, so a position already taken.
Absolutely. And then you became a senior advocate of Nigeria. But let's also talk about that now. How did you attain the prestigious title, and how has it been since then?
Well, before I became a senior advocate in 2006, I became the Attorney General of Ekiti State. Then the governor and his deputy were impeached, and then the whole state was going into chaos, and the president had to step in. Arguably, some would say he didn't have such powers, some would say he had the powers. He declared a state of emergency and appointed General Lurin as the administrator. I was called upon to serve as the state attorney general, the only commissioner to him, and I was attorney general to acting governor Tope Ademiloye. Subsequent to that, I was attorney general also to Chief Segun Oni. And then while there was a tribunal, court of appeal judgment asking for a rerun of the elections, he had to step down. And then the speaker became the acting governor for 3 months. I was also the attorney general to the speaker until Chief Oni won the rerun, and he returned as governor.
And then we enter into your son era.
Yes, if I must tell you, it was tough. I had to apply like 9 times, but we thank God that I eventually got awarded. After I had attended, I think, about 5 interviews. That means I got to the final stage about 5 times. And you know, the standard is really high. I must consider maybe perhaps those earlier applications, I wasn't particularly qualified. So I got it when I was deemed qualified. That's why I will tell you, a lot of people say the award is given on patronage. I don't agree.
You've also served on the Council of Legal Education.
Yes.
So how would you sum up the legal profession and your take on young lawyers and the level of education, legal education in the country?
Well, starting from the level of legal education, I want to believe that the level still remains very credible. I think the problem we have basically is not limited to legal education. It's limited to the entire educational horizon in Nigeria. The quality of our graduates has not really been impressive, and the law students and law graduates are no exception. But I think the law school is doing a lot to ensure that the lawyers are well trained, and only well trained ones are made to qualify as lawyers. I still believe a lot would have to be done. There are so many universities, even universities of technologies, offering law courses. I don't think it's right. I want to believe that the proliferation of law courses in our universities is too heavy. That's why, somebody told me that we now have about 110,000 lawyers in the country. The economy is not expanding fast enough to accommodate all the lawyers. That's the reason that you find the lot of lawyers now veering into other businesses, young lawyers, setting up boutiques, setting up other kinds of businesses. But I believe that if the economy over time would grow, all the lawyers will be accommodated. And as seniors, I want to say that we should encourage our younger ones very well. Good pay, good working conditions, such that they are also inspired to remain in this profession and then make something of it for themselves.
All right. Thank you very much, Mr. Gboyega Sanmi Oyewole, for this revealing interview into your world.
Thanks for having me.
Mr. Oyewole, Senior Advocate of Nigeria, is the principal partner here at Lords and Temple Chambers here in Lagos. And that's it on The Advocate for this week. Legal Focus continues in a moment. Please stay with us.
Welcome to today's segment of You and the Law. Today, we'll be discussing the rights and obligations of a tenant under the law. Who is a tenant? A tenant is a person that is given the right to stay in a premises or to use a premises for a definite and defined period, usually for a consideration. The consideration here is money, which is paid as rent for the duration of the tenancy. What are the rights of a tenant under the law? For example, under Section 6 of the Tenancy Law of Lagos State, a tenant has various rights which are recognized. These rights principally is the right to peaceful and quiet enjoyment of the premises. Under these rights to peaceful and quiet enjoyment of the premises, a tenant is entitled to the right to privacy. A tenant is entitled to the right to exclusive possession of the property, save and except for the landlord's restricted right of inspection. What that means is that even when you are a tenant in a property, the law gives the landlord a restricted right to assess the property for the purpose of determining whether that property is still in a tenantable state. A tenant is also entitled to use common places within the premises for lawful purposes. That includes the veranda, the parking space, and so on. A tenant is also entitled not to be disturbed, freedom from encumbrance, freedom from disturbance from the landlord. The landlord does not have the right to be disturbing a tenant unnecessarily. These are rights that are recognized under the law. Again, a tenant also has the right to a quit notice in the event that the landlord wants to determine the tenancy. This is also recognized under Section 13 of the Tenancy Law of Lagos State, which is one of the laws that are applicable in Nigeria. We also have similar provisions under the various laws in the state regulating the premises and responsibility and rights between the landlord and the tenant. Therefore, what are the obligations of a tenant? Again, under the Tenancy Law of Lagos State, specifically Section 7, a tenant has the obligation to pay rent as at when due in the manner prescribed in the tenancy agreement, if any. The tenant also had the obligation to pay rent and rates and charges. This includes bills for electricity consumption, for water consumption, and of course for general keeping of the premises where such is envisaged in the tenancy agreement. The tenant also does not have the right or the power to either lease, mortgage, or in any manner assign the demised premises, the property, to any other person without the consent of the landlord. In fact, that cannot even be done if the landlord does not approve of it. The tenant also has the obligation to ensure that the property is in a tenantable state. What does that mean? We see a situation where people go into premises, go into properties, and they just do not take any care to ensure that that property is in a good state. That is part of the obligation of the tenant. The tenant also has the duty to ensure that that property does not change in nature. For example, where someone is given a one-bedroom flat apartment, the law does not give the tenant the right to now convert that property to a two-bedroom apartment or to a self-contained apartment. That cannot be done. That will amount to reasonable and substantial alteration to the nature of the premises. Again, this cannot be done without the consent of the landlord. What can the tenant do if the tenant wants to effect substantial repairs? The law says the tenant must seek the written consent of the landlord. And where this is done, under the law, the tenant is entitled to recover the expenses incurred in the process of carrying out substantial repairs on the property. In summary, what we are saying is that the law is basically made to protect the tenant, but the tenant also has obligation under the law which he has to keep to.
Justice Nicholas Oyewole of the Federal High Court has granted EFCC's application for the final forfeiture to the federal government several pieces of jewelry recovered at the residence of former Petroleum Minister Diezani Alison Madueke. The judge said she failed to prove how she lawfully acquired the 2,149 pieces of jewelry, including a customized gold iPhone, all valued at $40 million. In EFCC's application brought pursuant to Section 17 of the Advance Fee Fraud and Other Related Offences Act 2006, the anti-graft agency had argued that the respondent's known and provable lawful income is far less than the property sought to be forfeited. But counsel to the former minister had stated that some of the jewelry were gifts given to her. The judge also dismissed the respondent's application to set aside the interim order of forfeiture granted in July. Diezani Alison Madueke insisting that she acquired the controversial assets even as a minister, having run a successful private practice in the oil sector.
For that reason, the court decided that we didn't follow the procedure laid down by the Advance Fee Frauds and Other Related Offences Act. So in essence, what I'm saying to you is that it's not that we didn't show cause, it's that we chose a different approach. And the court decided that our approach was not in keeping with the law.
We have gotten the order, interim forfeiture was granted and the final forfeiture was granted. The respondent did not prove to the court and not satisfy the court as to how she acquired the property, i.e. the gold in issue. I think from here we are okay for now. It's left for them to, if they are not in agreement, then they can go on appeal, which is their right.
A federal high court sitting in Lagos has discharged its own order granted to the Asset Management Corporation of Nigeria, AMCON, to take over the Lagos property of former Governor of Cross River State, Donald Duke. This over a disputed debt of more than 500 million naira. Shortly after the court order was made in August, parties went into talks, exploring amicable settlement with the backing of the judge. And following confirmation that Mr. Duke had fulfilled terms of the settlement by paying 340 million naira to offset the debt, Justice Nicholas Oyewole adopted the terms as full and final judgment. He discharged his initial order for AMCON to take over the Ikoyi property used as collateral, as well as on freezing Mr. Duke's bank accounts.
Defendants have met their obligations and they have paid the agreed reduced amount, and the matter is now over.
AMCON had a right. The defendants have engaged subject to that right, and the issues have been amicably resolved. Discussed parties have settled the issues, and the court has only, put its mark on the agreements of the parties.
That's Legal Focus for today. Thank you so much for watching. Let's do this again next time. Bye-bye.